Hey, Jason. Thank you for joining me. This is really
Hey,
exciting.
it's great to be here. It's always fun to talk to you.
Like I said, I love the water bottle and the hat collection. I'm always trying to figure out, like, I have a glass wall behind me and it's really boring to look at. Always trying to figure out how I can position something here or what I should put there. So maybe water bottle collection. That's now I have an idea.
All this stuff started snowballing. One day I was talking to a client who was wearing a hoodie with their logo on it, and I said, "Hey, wait a minute, how come I don't have your sweatshirt with your logo on it?" And they said, "Oh, you want something? Okay." And they sent me merch, and then of course, once I put that behind me, and everyone else said, "Oh, wait a minute, I don't want to be the only one," so I don't
So you
left
just got an
out. So
influx on hats
people
and water bottles.
stuff. So yeah, I keep getting baseball caps and water bottles. So I put those behind me. It's a fun and easy way to show all the folks that I like to hang out with in the space.
It's my favorite thing when I go and visit clients. I always raid the swag room. It's
Absolutely.
my house is like flooded with t-shirts, black t-shirts predominantly in this space. Funky
Just so
socks.
at the end of we're doing some spring cleaning, and I've got two kids, and we were cleaning out the kids' drawers because they outgrow stuff. And we had the pile of clothes that we're going to keep and the pile of clothes that we're going to give away. And then we had a third pile. I said, "What's that?" And she said, my wife said, that's all the swag crypto t-shirts that you've brought back from conferences for the kids. I know you're about to go to consensus. Do not bring back any kids t-shirts."
My wife literally said the same thing. I came back from NFT NYC with two suitcases of like canvas bags and t-shirts, and it's always the first thing that goes after a spring cleaning. So they're disposable. Great. I'm so happy to have you here. The way I typically like to do this, like I mentioned, is give you the opportunity to just introduce yourself to our audience. In my world, you're kind of a legend, within the crypto legal space. But for those of my listeners who are not familiar, it would be great if you can give them a little bit of a background. So, like I said, deep dive as much as possible. I want to know like your deep roots and then how you got to where you are today.
Deep roots. Well,
Welcome to Beyond the Code, the podcast where industry experts and brilliant legal minds discuss the impact of new emerging technologies. I'm your host, Yitzy Hammer, a lawyer and tech enthusiast. Join us as we explore the legal, regulatory, and ethical issues surrounding AI, blockchain, and more. Get ready to go beyond the code and stay ahead of the game.
okay. Hi, everyone. I'm Jason Gottlieb. I'm a partner and the head of the digital assets department, as well as the white collar and regulatory enforcement group here at Morrison Cohen, a law firm in New York. So I spend most of my days at the intersection of digital assets and the regulatory enforcement space, doing regulatory advisory work, enforcement defense, protecting my friends in the space from the government, as well as litigation between and involving crypto companies. A deep dive on how I got started in this. Well, as many of my friends know, I am a longtime tech nerd. Going back to when I blew all of my bar mitzvah money to buy my first computer, an Apple IIc, and I learned to program
Nice.
in BASIC on that computer. I've been a fan of computers and technology all my life. Now, I don't have a comp sci background. I didn't study that in college. I actually studied English literature, where I learned to know the elements of a good story, and that goes into my litigation background. I also studied Japanese and Japanese politics, and that's what actually
Cool.
took me to my first job. I went to college, graduate school, and I worked in computer labs all that whole time. And then later, I went to Japan and worked for a couple of years at a Japanese internet and computing company, where I was doing some translations of technical manuals, some interpretation, and some technical work. That was a lot of fun, and it sort of dates me to explain what I was doing. We were helping move people from 26 baud to 56 baud modems for their home internet. again, this just sort of shows even more than the gray hairs in my beard. It shows how long I've been a tech nerd. After law school, I went to Cleary Gottlieb, one of the big firms here in New York. Was focused mostly on international arbitration at the time, really leveraging my experience working in Asia. But as time goes on, I started to move into more regulatory enforcement and white collar defense. Started working with a legendary partner at Cleary, who is actually now a federal judge on the Southern District, Louis Lyman, and learned everything I could from him about not just how to be a great lawyer, but how to be a great defender against the government. So I took that knowledge, mostly SEC work. I went to a different firm where I did a lot of CFTC work, and I came here to Morrison Cohen in 2016. I had in mind that I wanted to build a fintech enforcement practice. And I probably didn't mention blockchain and crypto in my interviews because it was, early 2016 and nobody knew what that was yet. So they would have kindly invited me to find the door on my way out. But I had it in the back of my mind that crypto was going to be a thing. Digital assets was going to be a thing. I'd had this a few years before that. I'd read the Satoshi white paper, and to show you, sort of the legal nerd that I am, as well as the technical nerd, my first reaction on reading this was that regulators were going to hate it. And they did. It took them a few years to notice it, but when they did, they absolutely hated it. And I thought that there was going to be a market for people who were exploring in that field, for people who were building in the field, but who were being misunderstood by a government that wasn't understanding what digital assets were or how they worked differently or outside the set of rules that we had. And I think that eventually happened. And starting in 2017, when the SEC started its new cyber unit and promptly brought a case against a couple of Quebecois folks that it accused of conducting an unregistered securities offering, I represented that team, the PlexCoin team. And from there, from December 2017, we were really off to the races, and I never looked back.
And then you just kind of stumbled down the rabbit hole. And
it was a gigantic rabbit hole, and we fell and fell, and like Alice, I guess we're still falling down forever. Between 2017 and now, we've really expanded. So this project at my firm started with just me working part-time for a couple of crypto folks. But over the years, as we developed our expertise in it, developed more connections in the space, it really took off. And I think it took off most during the pandemic. There were really no silver linings about the pandemic. The whole thing was pretty uniformly awful for everyone.
Except
but one of the things that it allowed us to do was it forced everyone to Zoom, right? No more were you going to go to a client's office. You weren't going to take your team of 5 people, go to a client's office, try to impress them, take them out for dinner, wine and dine. All of a sudden, the world was flat and quick. So we could have conversations with builders all over the world and talk to them about what we were seeing in the space, what they were seeing in the space, and really kind of try to explore how they could protect themselves. And this was a huge advantage for, our firm is a relatively smaller firm compared to some of the big law giants who are prominent in this field. Folks like Skadden and Latham and Goodwin, which are absolutely fantastic firms. But we were able to talk to builders as well. And a lot of these folks, for them, Skadden and Latham and Cleary and Debevoise and Morrison Cohen were just names of law firms, right? There was no particular meaning associated with any of them. So it was great to be able to get in and just show that we could speak about the field. And eventually we were fortunate enough to have a lot of clients trust us, and it took off from there. And I'm very happy these days to be, frankly, involved in the same types of matters that a lot of my friends at these large firms are, because they're some of the hardest, thorniest, most headache-inducing matters out there. but we all get to work on it as colleagues together. Uh, and we were having a really good time doing that. So since 2017, I've built the team here. So our little department here is now 3 partners and 4 associates working full time on these digital assets litigation matters. And we're building more. More is yet to come.
Would you say that what set you aside from these other firms, reputable firms, and enabled you to grow this practice is that you had that technical interest, technical background, geekiness to you, that you understood the actual products that the clients were dealing with on a deeper level?
I think that's helped a lot. To have some understanding of how the technology works is absolutely critical. And I think we had a big advantage from the beginning from doing that, from really doing the deep dive. And, when a client gets on the phone with us and says, okay, so do you guys know what liquid staking is, et cetera? We know it, we've done it, we've represented clients in the space. We actually literally do it ourselves to figure out how the technology works. And that's something that is a pretty big advantage. Now, I'm not saying that others don't do that. I've got plenty of friends at lots of other firms who do that. And this crypto lawyer space, particularly in the United States, but really around the world, has grown tremendously. I mean, you know this well, right? Being one of them. So a lot of us have kind of bonded together. And what I've found is there isn't the sense of competitiveness or sharp elbows that you might find in some other places. The
Absolutely.
people in this space who are ostensibly my biggest competitors are also good friends. And if they're competitors, it's because they're just as good, just as smart, just as knowledgeable, and I would trust them with my matters. So I frequently have clients who say, if we couldn't hire you, who would we hire? And I've got a good supply of referrals. If I'm conflicted, I've got a good supply of referrals. And these are all our friends. So we work together in the space very frequently.
Yeah, I agree. There's definitely like it's a more kinder space than you'd find in other, I guess, like legal subsects. But I've said many times, there's like all these fantastic groups on Twitter and Discord and on LinkedIn of like crypto lawyers that is very tight knit, and the sharing is very it's something I've not seen anywhere else. And I think part of that is probably because a lot of these legal issues that arise are evolving, and a lot of times when you get a new client, you're faced with questions that you never have been faced with before, maybe due to the technology or due to the complexity of the scam or whatever it is. And it's great to just kind of bounce around ideas with other legal professionals, and that way, sharing is caring and that kind of thing.
I, I find the space fascinating, really for a couple of reasons. One, just like the internet, like it truly is international. All right. I mean, crypto goes around the world instantaneously. So you have to deal with the legal regimes around the world instantaneously. When clients come and say, how can I avoid trouble with the SEC? I can help them. But, you also have to figure out, can you do business in Europe, in Hong Kong, in Japan, Canada, and anywhere else around the world? So you really do have to have an international perspective and friends in international regimes, as well as to know just enough to know. I'll never be able to advise someone on the ins and outs of MiCA. That's just not what I do. I'm not a European lawyer. But, it's useful to have at least an idea of, wait a minute, there's a red flag here. You need to go talk to a lawyer somewhere else. So the internationalism is one place these communities can be very, very helpful. The other is bringing together lawyers from different specialties. So, I've done a lot of securities litigation, class action defense. And, in those spaces, the security is a security, and that's it. It started as a stock. It will always be a stock, and there's nothing different to it. But when we're dealing with digital assets, I mean, effectively, they're just software, right? So it can be a security, or it can be sold as part of a security, or it can be a commodity, or it can be payment, or it can be some piece of intellectual property, or maybe it's nothing at all, or maybe it's all of these things. So when you're dealing with something that is that flexible, being an expert in securities laws only gets you so far. And I'm pretty comfortable around the securities laws, pretty comfortable around the Commodity Exchange Act. Um, I do a lot of work in payments, but there are others who are far, far better than I am at that. So, if I'm friends with someone who used to be a general counsel at Treasury, or friends with people who do nothing but state money transmission licensing, it makes very little sense for me not to refer matters to them, or
Sure.
or at least to have them on speed dial for isolated questions, the same way I'm on their speed dial for securities questions. So I find when if a complicated case decision comes out, right? Just the other day, we saw the motion to dismiss decision in the SEC v. Binance case. And, I can kind of instantly go to some of my Telegram groups where if there are areas that I'm an expert in, I can weigh in and give my thoughts. And then other people will have different interesting angles about how it affects their fields in ways that I probably haven't thought of. That's a way that all of us can share that information, which I think in turn helps us protect all of our clients going forward.
So I'm curious if, as a securities lawyer, presumably you were doing securities law before 2017?
Yes.
Okay.
Yes.
So as a securities lawyer, did everything that you thought you knew about securities, was it kind of just like thrown into confusion when you came into the crypto world and you saw that, the way we define securities has not evolved since Howey, and maybe this is not the best way of going about evaluating whether or not this or that token is a security, and B, the way the SEC to date has been enforcing or not enforcing various projects, and whether or not it should be the SEC or the CFTC who deals with these things. Under if I had asked you prior to 2017 how the SEC would have reacted to these things, or whether or not they would be securities, would you have still said what you're saying today?
Yeah, so it's kind of an interesting thing. When we saw the rise of the ICOs in 2016, 2017, I looked at that and said, it looks a little bit like a securities offering, but it's not quite that simple. It doesn't quite fit. Some of my more senior colleagues in securities who've been around a while said, "Oh, we definitely think this looks like a securities offering," but that was based more on this general principle that the law is super flexible. The SEC has immense reach, and pretty much everything investment related should go to the SEC. I guess if you're a longtime securities lawyer, of course you think the SEC is the ultimate authority of everything. And we've really seen that in some ways reinforced, right? Courts have said that a lot of these ICOs were securities offerings, but it's been really complicated since 2017 with a number of conflicting rulings on what I think are some of the harder questions. I think once the early ICOs were tarred and feathered as being securities offerings, and I think some of them probably were, people responded to that and got a little bit more creative. They said, well, the law says I can't do X, so I won't do X, and instead I will do Y. And there's an interesting debate about, how far can you go? To a certain point, you can say, well, the laws are flexible and you're just trying to, change something that's form over substance, that's not really any different, versus actually this is different. And the law is not designed to cover this sort of activity. And I think that in the last, 4, 5, 6 years, we've really seen an upswing in that kind of creativity, designing things around what the law says, saying we're not violating the law. We are very literally not violating the law. And the SEC has come and said, well, we think you are anyway. And that
because
getting mixed results in the courts.
Because the interpretation of the law has changed so vastly?
I don't think it's the interpretation changed. I think it's that the law didn't anticipate a something that could be flexible and malleable. So kind of let me go back a little bit on this. Back to the Howey test, as you said. So in the securities laws, there's a definitions for stocks or securities, bonds or securities, all sorts of other things are defined as securities, including investment contracts. And crypto is not a stock or a bond or anything else. It gets lumped into this investment contract. The investment contract rubric comes from this 1946 case, SEC v. Howey, which I'm sure all of your listeners know by now. Everyone can probably recite the Howey test by memory at this point. And everyone appreciates the irony of judging these cryptographic technological assets by a rubric that was designed the same year that the ENIAC computer came out. There's no way on earth that the people who were designing this could have conceived of this notion. Now, they meant the Howey test to be flexible, to be adaptive, but not quite this adaptive. And there is a huge fundamental difference. If we go back to Howey, right, it was about interest in the orange grove. And the oranges themselves were not the securities. The interests were, and the interests were transferable. And those interests were basically linked to the oranges, right? If there were no oranges, then your investment was going to be worth anything. I don't think that the Supreme Court in Howey, or really anyone since, has thoroughly grappled with the notion of, okay, well, what happens if you can sell the oranges separately from the interests? What happens if these are actually separable things? And then to complicate it, what happens if the oranges are not actually just only oranges, right? Remember, it's software. So unlike an orange, which is kind of always an orange and will always be an orange, if it's software, if it's a software graphic of an orange, something I did up in Photoshop, then I can easily change it so that it's an apple or a grape or a dinosaur or the universe, right? Software is as infinitely changeable and adaptable as the human imagination. So when you have a token that can be the orange that's sold as part of an investment contract, but then not only could be sold separately from the investment contract just on its own, which is kind of what we see in trading on Uniswap, etc. It's something that's changeable and usable and malleable and programmable. Like, I think what we're seeing of tokens right now is the thin end of the wedge, right? Cryptocurrency is a thin end of the wedge. It's easy. It's easy to digitize money or value in some way. And everyone understands it, and it's kind of simple. But digital assets are much broader than that. Assets that can be recorded on a blockchain are much broader than that. I think that as we grow, you're going to see more and more assets be complicated and traded on blockchains. So increasingly, our lives are digital. Your social media profile is a digital asset, right? Your dating history on Hinge or Bumble or some dating app is a social is an asset. It's a digital asset. I've been married 30 years. I don't have a dating profile. I think say it would be an extraordinarily boring digital asset. But I assume that for some of my younger colleagues, that is a particular digital asset that they wouldn't want to be exposed to the world or tradable. But all of these assets are the same, really, in one fundamental way, which is their software. They're strings of ones and zeros. They're coding that can be recorded on a blockchain. So all of the rules that we're creating for cryptocurrency will be applied and cross-applied and complicated for rules that we apply to all other digital assets. And I think this is the reason that the older gray-haired securities lawyers that I consulted with back in 2016, the Supreme Court back in 1946, and the current leadership of the SEC haven't really grappled with the implications of what it means for a token to be sold as part of an investment contract, but for that thing to be separable and then infinitely malleable. And that doesn't seem to me like something that the Securities and Exchange Commission, which governs securities and securities exchanges, is very well equipped to deal with. So by asserting their authority over these digital assets, they're really trying to expand into something that's going to be a much larger field and a much more sensitive field in the coming decade. That got very philosophical.
No, that was phenomenal. As a non-American, okay, I'm from Israel, looking in from out, it seems that the regulators, the SEC in particular, are behaving sort of immaturely, irresponsibly vis-a-vis this subject. Are the courts behaving more appropriately? Are the courts looking at this in a? Did they understand the magnitude of the hour? And is it just the SEC that's kind of just like shooting in all directions, or is it just everybody over there is going?
So I think that the SEC is certainly kind of shooting in all directions, but it's in some ways acting rationally, right? It sees things that it thinks are securities or investments that it governs in some way, and it's trying to expand its authority, as is pretty much the case for all government agencies almost all the time.
At the same time, it has to remember that its purpose is to protect U.S. consumers, and if what it's doing by being inconsistent and unclear in its guidelines is just driving U.S. consumers out of the U.S. to have to, indirectly invest in these unregulated products through VPNs or whatever other means or offshore companies, then you're not protecting the American consumer. And it would be much better to give clear guidelines and to have everything funneled through you or through the CFTC, whoever is the responsible party. But in the end of the day, the American consumer would have a babysitter or would have somebody who's, looking out for their best interests.
Yeah, you're completely right, and the SEC has sort of lost the forest for the trees here by claiming they want to regulate all of these digital assets and forcing people into a situation that they keep saying, please come register, but they don't allow a path for registration. And all that does is force companies to go overseas or offshore or block the US. But it gets even worse than that. When the SEC brings enforcement actions, because of the nature of the Howey Test, right, which talks about the efforts of
others,
the efforts of the principals who were offering the assets as being key, and the objective signs that you should be relying on those others, the public would be relying on those others. The SEC looks for statements that are made. So they say, well, you folks who released the asset, you told the investing public all of these facts about the token. And that just shows that it's a security that you should have registered and you didn't. But what is the incentive? What incentive is the SEC creating there? The incentive is that people shouldn't say anything about their tokens. But that's terrible, right? If you actually want disclosure, we are theoretically a disclosure-based regime. If you want people to disclose, you actually have to have them disclose things. So the SEC has created all of these, damned if you do, damned if you don't traps, right? If you say things about your tokens, well, that just shows that it's a security that you should have registered, but you can't register. And if you don't say things about your tokens, well, you're not giving people the disclosures they need, and you're bad people for that. So they've, even if you accept that they've come with good intentions, and I'm not entirely sure that they have, but even if you accepted that they have, that they want to protect the investing public, they want to grow capital markets, I think the way that they've gone about doing that has had exactly the opposite effect, and it's really sad. We're losing a lot of ground to folks outside the United States, and we're ceding jobs and leadership in this area. At the best case scenario, we're ceding financial leadership to Europe. They've come up with the MiCA regime, and maybe we think Europe compared to the United States is sort of slow and sclerotic and bureaucratic and boring. But that's the best case scenario, right? In the worst case scenario, we're ceding to China, where the government wants to have digital assets that can they can track and trace, so they can spy on your every move and sell all of your information to whoever they want to, or even worse, to non-state actors or people who don't want to be subject to any regimes. So they're kind of existing in gray areas that we prefer didn't exist. So we're really ceding a lot of leadership. But Yitzy, you asked, are the courts acting more responsibly? And I will say, for the most part, yes. We've got a lot of really great judges, and I'm not just saying that because I appear in front of them regularly. I really do mean it. We have a lot of really great judges who are wrestling with these issues and coming to different decisions. So, we have a judge like Judge Torres in the Southern District of New York who had a pretty thoughtful decision on XRP and whether XRP is a security. And I think the important lessons from that decision were that the token itself was not a security. And as a result, you had to look at a very transaction by transaction based approach. She ruled that, the initial sales to institutions could be securities offerings because it very much looked like it fit the Howey Test. That sales over exchanges were not, because people who were buying them were not investing in a company. They were just buying a token. And that, payments to employees or grants programs, which are, as you know, are common in the field, are also not securities offerings because people aren't investing in the company. And then more recently, in fact, just last week, we had Judge Amy Berman Jackson in the District Court for the District of Columbia issue a similarly complicated ruling in the SEC v. Binance case, where Binance filed a motion to dismiss. And parts of that case were dismissed and parts will go forward. But Judge Jackson reinforced that it is a transaction by transaction approach. This makes sense. This is consistent with Howey, right? If you're selling the investment contracts that have oranges as their subject, that could be an investment contract. But then if you're selling the oranges later, that's probably not. If you're selling that contract to someone else in some facts and circumstances that don't make it an investment in the company, which is eminently possible in the case of crypto, then maybe it's not an investment contract. So I think what she underlined from Judge Torres' thoughtful opinion is that these are very facts and circumstances laden tests. And you cannot do what the SEC was trying to do, which was to say, once a token was sold as part of a security, it's always a security. So the tokens are securities, and everyone trading those in the secondary markets are trading in securities. That's just not the law. I mean, as our friend Lewis Cohen wrote at great length in his really wonderful article, the short title of which is The Ineluctable Modality of Securities
I love that
Law.
title.
It's out of Ulysses, and I absolutely adore Lewis for doing that. But Lewis's really great article really surveyed the law to see is it the case that the token can be the security, and the answer is clearly not. Like nowhere in the law, not in Howey, not since Howey, has any court ever found that to be the case. And I think it's important for judges to understand that. Now, unfortunately, the SEC has a habit of ignoring the district court judges that it doesn't like, or the district court rulings that it doesn't like. So we saw them lose part of the case in a motion to dismiss against Coinbase, where the judge dismissed on a motion to dismiss the allegations that Coinbase's unhosted wallets were acting as brokers. But then the SEC turned right around and sued Consensus Software, alleging very much the same thing. Despite the fact that they literally had just lost that issue in the Southern District of New York, they chose to refile on some of the same types of allegations in the Eastern District of New York. So the SEC apparently feels unconstrained by previous district court decisions and thinks, well, since those aren't necessarily binding, it's going to just take its chance.
Try again.
We'll try again. But I want to underline, for anyone who might be listening, for my friends at the SEC, what message does that send about the rule of law, right? If you lose, so can projects do that?
Just
right?
keep
Judge Rakoff in the Terra case said, well, I think, these stable coins were securities because they could be used to purchase other securities. And now we've seen the SEC use that and say, well, this is the law. That's what this case held. But if the SEC is unconstrained by district court precedents, why should crypto companies care about district court precedents? Like, why would we care about the ATB Coin v. Ballester case? Why would we care about any of these district court cases if the SEC is free to say, well, that case was wrongly decided, we're not going to care about it? If that's the rule, then we can all just do what we want until the Second Circuit tells us otherwise. And I think that's just very corrosive for rule of law, right? It goes to this issue like, what is the law anyway? And if it's whatever the appellate courts say, well, okay, I guess that's fine. But if you're just completely ignoring district courts, that's a huge problem, and it all of a sudden leaves a lot of holes in the law.
This is a great time for a plug. In addition to being a phenomenal lawyer, Jason is also the editor and distributor of Morrison Cohen's Crypto Litigation Tracker, which is really a work of art. I'll include it in the show notes. So, yeah, in addition to creating lack of clarity, it also just puts a lot of strain on the courts. I presume that there's more and more appeals if the appellate courts just keep getting more and more. I lost my English word for a minute, but I mean, I think.
No worries. But believe me, if we had done this in Hebrew, I think I would have gotten 3 words in before losing the next word. Judge Jackson complained about this actually in her decision on the motion to dismiss, and she said that the SEC's approach was really threatening to flood the district courts, because if you have to talk about each one of these tokens and the facts and circumstances of each sale of each token, then it risks flooding the district courts, not just with the cases for each token, but really you have to do an examination of any of the transactions. This is something a friend of ours, Kayvon Sadeghi, a partner at Jenner and Block, who's a terrific crypto lawyer in the space, just when he saw Judge Torres's opinion, he instantly grasped what it meant. And it means trench warfare. What that means is if each transaction, and even if you're grouping some transactions, if each transaction is subject to a facts and circumstances test, then the SEC can't come in and say, we think token X is a security, therefore all these transactions are securities transactions, right? If you're saying we think token X was originally sold as part of an investment contract, then you have to look to see, okay, well, are any of the secondary sales on Coinbase also securities transactions? What about secondary sales on a DEX like a Uniswap? What about sales in the private market? And for all of these sales, are there any distinguishing factors that would lead you to say, well, okay, maybe it was a security in this instance, but not in this instance? And what you've created is an incredibly cumbersome and unworkable test. And I think Judge Jackson was sort of complaining about the SEC's approach on this. And I think bemoaning, as Judge Fela did before her in the Risley v. Uniswap class action, really bemoaning Congress's failure to act and the SEC's failure to promulgate workable rules that we could all play by, right? If you don't know whether a token is a security in any given transaction, how do you know if you're breaking the law?
Right.
How is anyone supposed to react to this? If you bought tokens on the open market through a DEX, you don't know who you bought from. You're not investing in the company. You're just buying a thing. You're just buying it. That's because whether you are buying it for investment purposes because you think number go up, or whether you bought it because you think you really like the cute dog picture that's associated with the token. You just want to be part of a community, yeah, exactly. There's people can buy for all sorts of reasons. And how do they know if they're being scofflaws? How do they know if they're joining some DAO that's a partnership where everyone's jointly and severally liable for everything? Like some of these theories are nonsense, but judges are still being forced to grapple with them. As I say frequently, we're dealing with all of these neuromancer issues at a bleak house pace, right? We're really crawling through the courts. The courts are an incredibly inefficient way to get resolution on any of these, because it will take you years to get any kind of resolution. And then when you do, it's resolution that might be applicable only to the facts of that case. So it's only after building a large pool of those cases that you can draw some repeating lessons from. And I guess if taking the SEC's actions seriously, we have to wait for a pool of appellate decisions, not just district court decisions. And this is really not a great way to run a multi-trillion-dollar portion of the economy.
No. So I wonder, are you just a when shit hits the fan lawyer? Like people come to you solely to litigate when things have gone wrong, or given your experience with the courts, do companies and projects often consult with you in advance to try and mitigate risks? I'm asking because, like, a spoiler alert, I just finished Jamie Bartlett's phenomenal book on the OneCoin scam, and I'm actually having him on the podcast tomorrow to talk about some recent developments. And one of the things that really jumped out at me there was how much the perpetrator of the scam, Dr. Ruja Ignatova, really saw a lot of value in lawyers and in having lawyers on part of our team, both outside and inside counsel, and saw them both as I guess she didn't value their legal advice so much in order to implement it, but more as just kind of like, okay, I advised, and now like I could say that I advised, and also just having them, these letters in the box of I spoke to somebody, and I couldn't, like, surrounding herself with soldiers of sorts. So that kind of put things into perspective to me, at least in terms of how my own clients perhaps see me and my function and my advice. And I wonder to what degree clients draw on your expertise pre-enforcement actions.
So, we do that kind of advice. About my practice is probably divided into thirds. A third of it is defending folks from the government, SEC, CFTC, DOJ, etc. About a third of it is litigation. We're working on some of the larger class action litigations in the space, dealing with whether Compound is a security or whether the Lido token is a security. We handle the Pool Together class action, the Sarkuni class action. So we've done a number of these kinds of cases. But about a third of our practice is advisory, is forward-looking. Basically, how can you stay out of the other two buckets of my practice? And this is it's a different kind of thing. It's a different way of lawyering, right? When, as you said, the shit hits the fan, when people come to me, the stuff that they're in trouble for, the stuff that they're getting sued for, that's already done, right? There's nothing that I can do about what's happened in the past. We talk about what they've done and why it's legal, why it's illegal, why it's not so bad, why they're being unjustly accused of things, etc. But I can't change the facts. When you're advising, you can change the facts. You can advise folks to do the right thing, and it's important to understand all the ways that things can go wrong, so that you can try to help people avoid being in those buckets. But it's also a very difficult place to be, because the SEC just thinks all of crypto is a bunch of scallywags who should all be out of business. You've got a number of prominent folks in Congress who just think that crypto is used for money laundering and crime, and they don't really think any further than the headline they can get for saying that.
Not like fiat.
Right, exactly. Every time I hear money laundering and crypto, I look at the amounts, and then I look to see at some of the larger settlements from the traditional banks over the last 20 years, and those amounts are spectacularly larger. But look, any technology, any sense of any technology can be used for crime. Any kind of money can be used for crime. And it's not surprising that a new kind of technology or a new kind of money can be used for crime. The issue is, how do we help clients prevent from accidentally falling across regulatory tripwires? When I say that, it's because, if people like Ruja Ignatova were, if you're bound and determined to commit crimes, legal advice saying you should not commit crimes and here's how you can avoid committing crimes, very often.
It's not going to get you very far.
Not going to get you very far. And, I think in that sense, the biggest thing that lawyers can do is ensure that, they're not the ones who are aiding and abetting or committing the crimes themselves. And, I think for that, you can look, for example, to a former lawyer who went to work for Ruja, Mark Scott, who was sentenced to 10 years in prison for his role in that scheme. So when we're giving advice, we will tell people as best we can what is the law, how to protect themselves, how to do things legally. Most of my clients are really excellent and follow our advice to the T. Some of our clients have to make regulatory decisions. Like the SEC is saying, I have to do X, Y, Z. That's absolutely bonkers ridiculous. If I do that, we're completely out of business. If it's a gray area, can I do this? We will advise on whether they should or shouldn't be doing things. And if we say you should not be doing those things, for the most part, clients will listen to us. And I really hope that they listen to us, and because it's really for their own good. But there are some places where there is no regulatory gray area, right? It's one thing if we think, the SEC might come after you because they have an interpretation that is contrary to the law, contrary to what other courts have said. And that's something that we think a federal judge would side with us about. It's a little different when people are saying, hey, is there a regulatory gray area about money laundering? No, the answer is no. There's no gray area. Like if you get that wrong, it's handcuffs. And we're not going to advise that you can, you're in a regulatory gray area and you can take a chance on that. That's not regulatory arbitrage. That's crime, and that's silly.
But there may be gray areas in whether or not you need to KYC in certain situations, and how you can segregate the money, whether you're a custodian or you're not a custodian. In other words,
there absolutely are, and those sorts of there is a lot of gray area in the space. Like when are you acting as a broker? How do I know that I'm acting as a broker in a securities transaction? Going back to our previous conversation, if I don't know whether a particular transaction involves securities, how do I know if I'm an unregistered broker or not? Am I an unregistered broker if I'm a software developer who provides software that can perform those functions, but I'm not performing those functions? Right? There are a lot of places in the law where either there really is no answer, or whether the SEC thinks that there's an answer, but most of the rest of us think that answer is wrong. Like we just don't agree with that. That's just not right. There are places where an agency may think that their guidance supplies an answer, right? I've heard from the CFTC repeated references to their 2020 guidance about settlement in so-called 2C, 2D transactions. That's too far down a rabbit hole for this call. But, how much weight should the CFTC's own guidance get if it's unmoored from the statute itself? And I think the Supreme Court here just issued a case called Loper-Bright, which overruled the Chevron deference doctrine. And again, not to get too deep into the rabbit hole of administrative law, the Supreme Court has said we don't have to give deference to agency interpretations of the statutes. The judiciary is entitled to review the statute, and the judiciary can decide what the statute means. So we have certain agency guidance that, in my view, is completely divorced from what the statute says. It's just sort of how the CFTC would like to see the world work. And that's nice, but that's not the law. So it's kind of an interesting time to be in this space where the agencies are trying to tell us what they think the law is. The Supreme Court is saying that these agencies should not be given any deference on their interpretation of the law. And in the meantime, we're dealing with these products, this software that crosses into a bunch of different agencies at the same time. It is a very exciting time to be in this space. And I have to say, I'm having more fun now than I've ever had in my entire career.
I couldn't agree more. So speaking of fun, maybe you can tell us just one or two war stories, things that are not privileged or were maybe in the news.
So I guess here's a story, and I'll obviously some details are I'll leave out for privilege reasons. But going back to November of 2022, with the collapse of FTX,
Brutal.
I went to Los Angeles for mediation between two crypto companies, and it had nothing whatsoever to do with FTX. But obviously, FTX was on everyone's mind. As that week went on, and everyone was getting more and more tired from staying up all night, dealing with FTX issues on the side. And of course, we've got clients all over the world, so I'm talking to the Europeans, then the New Yorkers, then the Californians, and then when we move right over to the Pacific Rim clients, it sort of never ended. It got to Friday, and that was the day that FTX collapsed and went into bankruptcy. And it was clear that none of the crypto folks in the room had any more patience to deal with a mediation. So my clients left, the other side's clients left, everyone left. And I was there with one of my associates, Vani Upadhyay, who's just a terrific up-and-coming lawyer in this space. And we had flights that weren't leaving till the next day. The world was falling apart. So we decided we were going to go over to crypto.com arena and catch a Lakers game. So there we sat while at crypto.com arena as crypto seemed like it was heading for what could be its last days, taking in a ball game.
I wouldn't want to be in FTX arena.
Yeah, the only way it would have been more poetic if we were at FTX arena, but alas, we were not. So wow. we were at in Los Angeles. It was a surreal way to capture a surreal week, and that ball game felt like this 3-hour eye of the storm, right? Just sort of a kind of a normal thing to do for normal people to do, coming out of some crypto craziness and then reemerging into what would be the whirlwind of the next year and a half.
Wow. Okay, not the war stories I was looking for, but still, I'll take it. It.
It was privileged.
Yeah, fair enough. I'm happy that you kept it that way. Jason, this has been great. Thank you so much for coming on and for sharing. And I always need to give credit where credit's due. I've had the incredible privilege to work with you and some professional work with clients in the past, and you're just phenomenal. If anybody's looking, hopefully you won't need. If anybody needs a great crypto litigator for enforcement reasons or otherwise, Jason Gottlieb is your man, and I will include his details in the show notes. Is there like a particular platform that you're active on that people could? The litigation tracker I'll send, but just generally to follow your content and be in touch?
Probably the most active place I am is on Twitter, where I have an absolutely bizarre handle. It's Ohaiom, OHAIOM. And it actually is short for a...
Where did that come from?
So this is a completely off topic. I am an amateur musician, and I was involved in a band or a musical project called Our Hearts Are in Our Minds. This was back in 2009 when I started this account, and it started as an account to post music that I had composed and performed.
That's awesome.
And over time, it became a somewhat more eclectic account that I kept to handle, just because it's kind of.
What did you play?
I play a bit of everything. So these are albums on which I did, guitars, bass, drums, keyboards, vocals, horns.
Where could you find your music? Is it on Spotify?
It was on Apple Music until I stopped paying for that. I was receiving about $12 in royalties a year from it, which didn't quite pay for itself, and is about $11.99 more than it was worth, to be honest.
Okay, YouTube.
I'm not sure that I'm anywhere anymore. I think I have a SoundCloud page. I know I have a SoundCloud page.
Okay.
How's that for cliche? Come visit.
I want to play.
Check out
I
my
want to play some
SoundCloud.
music. I got this. Jason Gottlieb 2. Is that it?
I don't think so.
It's definitely not the Law and Blockchain episode 5, right?
Well, that may also be me. But
you got to play something. I'm not letting you go until you belt out at least one track.
Oh, wait. Wait. I think I can. It won't come up on my work computer, but I think I can get you something here. Let's see. What's a good thing?
Oh man, all I can find on YouTube is like boring crypto law videos.
All right, here we go. I'm just playing it on my phone.
All right.
That's some good closing credits music for you.
I like it. It's like a little bluesy. It's good. Is that you singing?
That is.
No, you got a great voice.
Oh, thank you. So
sing. I want to hear you sing. Come on.
No.
Come on. I like it. It's good. This is good vibes. Cool, Jason. I gotta redo my opening music now and closing music. This is awesome.
There you go.
Okay, this is what I wanted in the deep dive at the beginning. Like you totally glazed over this whole like music. Wow. Okay, cool, man.
I think if we're on audio only, if you're on video, you can see behind me. I've got a collection of guitars and a bass in a rack behind me. If it's
we're doing video. We're doing video. I don't see anything back there. I just see the water bottles.
Yeah, so it's back in the other angle.
Turn your camera. Turn your camera.
Turn the camera. Hang on, if I can do that, but I can.
Nice. I like that.
So whenever I'm bored in the office, I can pick this up and play. It kind of helps me think about some other stuff.
That's great. Okay, I feel like I look at you so different. You have a soul. You're not just like an empty lawyer person. Very cool,
no,
man.
I'm an empty lawyer person too.
We all are empty lawyers inside somewhere. Cool. Jason, thank you so much. It's been phenomenal. Be well. Hopefully we'll have you on again in the future when things are no longer privileged and we could talk about the gory details.
Always happy to be on and talk.
Thanks so much, man.
All right. Take care.
Thank you for listening to Beyond the Code. If you enjoyed this episode, make sure to subscribe, share with your friends, and to tune in again next week for more fun and insightful conversation.